Ottawa lawyer, although I've also practiced in Calgary. I was called to the bar in '95. I went to the University of Ottawa Law School and have been practicing since then, pretty much most of the time on my own as a sole practitioner. And I also practiced, I went out to Calgary in 2008 and was licensed in Alberta and practiced there for a couple of years in wills and estates. I've also taught a course to second-year paralegal students at a college on wills and estates. So I have a bit of a background in it. So I'm just going to have a PowerPoint presentation this morning that I'll go through. And it's up to you if you want to ask me questions as we go, if you want to wait to the end. I think we're pretty flexible here this morning. So sometimes it's easier if it comes up to discuss it, although it may be coming up in the next panel. But then in that case, I'll just mention that. So we'll start with planning for incapacity. And that's for situations where something happens and you're no longer capable of taking care of your affairs. And there can be many reasons why that might happen. It could be illness, it could be travel, you're out of the country, it could be a temporary or a permanent illness. And if you and when we talk about incapacity, planning for incapacity, we're talking about areas that affect you in your daily life. And as it indicates, it's a very much overlooked area of estate planning. People will often do their will, but they don't think much about doing their powers of attorney, and a lot of people don't really understand how a power of attorney actually operates or what the necessity of it is. The power of attorney for property, a lot of people don't understand that what it refers to is more than just property. People think of real estate or their house or cottage or whatever, but it's actually much more than that. It covers your financial affairs, it covers contracts. It's quite powerful. Because if you don't have capacity and you have to go into, for example, a long-term care facility, someone needs to sign that contract for you. And that's what I'm talking about when I say it's more than real estate. It affects you. It's the person who will sign that contract for you to go into that long-term care facility, for example. Or if your house needs to be sold because you're incapacitated and you've gone into a care facility, then you can't, if you're not competent, you can't sign the agreement of purchase and sale, for example, if the house needs to be sold so that you can then have access to the funds for your care. And if you don't have a power of attorney, you yourself, if you're not competent, cannot sign that contract or that document. So that puts you in a very awkward spot if you need to get access to funds from the sale of your house. One example, just even to show you how small an area, but what a large impact it can have, is I actually had a client who unexpectedly went into the hospital and was going to end up staying in the hospital and, excuse me, was going to end up staying in, oh, I thought you were closing the doors. Was going to end up staying in the hospital. So her two daughters went to change her address at the post office. The post office would not allow them to do it without a power of attorney for property. So that's how intimate it can be. It goes right to the heart of your day-to-day living. So as I said, it's a very powerful document, and it also, as I mentioned, deals with your financial affairs. And that's where the most power is. So you want to make sure that whoever's dealing with your financial affairs is someone that you trust, and that is someone that you feel comfortable with dealing with your financial affairs and every other aspect of your business life, so to speak. So you really want to make sure that you have control over who's going to manage your affairs if you become incapacitated. And that's when it comes into effect, is you can do it one of two ways. You can either have it come into effect on the date of signing. Some seniors do this if their adult children are dealing with their finances, etc., their banking. However, if you're quite capable of if you're still dealing with your own affairs, then my recommendation is usually only, to have it come into effect only if you become incapacitated. As well, you cannot, and many people are misconceptions on this as well. You cannot sign or create or put into effect a power of attorney for property if you are incompetent or incompetent. You can be incapacitated and not incompetent. I've actually had a woman who had a stroke who didn't have a power of attorney, and she was a senior, and her sister and she were very close, and that was her only living relative, and her sister wanted to give the social worker at the hospital the information and decisions that were required with regard to her care, and they were saying she needs to have a power of attorney, so we had to wait. And then these are two lovely women who I had constantly seen over the years and knew, who kept saying to me, "I'm going to come in and get that done, we're going to come in and get that done," and never quite made it in. And then I ended up having to wait until she regained some power of speech after the stroke, and the doctor said she was okay, because I make sure I get, when someone's in the hospital, I make sure I get the doctors okay, that they understand. The level of understanding doesn't have to be terribly involved. The person just needs to understand, I want someone to take care of my financial affairs, this is the person I want, and they're going to have the ability to deal with all of the aspects of my personal, my financial affairs, etc. So that's the level of understanding that's required, but there has to be at least that, and the person has to be able to give me instructions. You cannot take instructions. I have no idea what this is doing. You cannot take instructions. This is not my computer. I just want to say, you cannot create a power of attorney for someone else. You can't say, my dad needs a power of attorney, I'm going to come in and give you the instructions for it. I can't do that. I have to get the instructions. Only the person whose power of attorney it is can give the instructions. Only that person can revoke it, only that person can amend it, and they have to be competent at the time. So you definitely don't want to leave it until you're in the hospital, and I have to wait for that window when you become coherent again and get that okay from your doctor. And even though this client was coherent, she was able to give me instructions, but it was she was coherent and able to speak, but the speech was very affected by the stroke. So it was it took a bit of time and energy and effort to get those instructions. So you don't want to be waiting until that point. And the power of attorney, now the other power of attorney, there's the two of them. There's the power of attorney for property, which deals with your finances, Revenue Canada, whoever, and that's what I was referring to earlier. It's not just the real estate, as I said, it's Revenue Canada, it's if you want to sell your house, it's if you need a contract to go into a long-term care facility. Those are all of the things that are covered by power of attorney for property. And just to say too, the power of attorney for property that you sign at the bank, that the bank often has you do, that's just for the bank. That's not for Revenue Canada, that's not to sign a long-term care contract, that's not to sign your income tax return, have somebody do your tax returns and sign on your behalf. That's not going to be any use at all to you if you sell your house and need to sign the documents. That doesn't work. It's only specifically for the bank. It's what's called a limited power of attorney. Now the power of attorney for personal care is the other document, and that deals with areas of medical consent, health care, nutrition, safety, shelter, and housing. It's also, we used to have a living will, and then this legislation came out, I think it was in 1992 or 1996, which replaced, which formalized it, shall we say. So if you want to put anything in, or if you want to leave any instructions with regards to life support or resuscitative measures, etc., or any kind of medical directions, whether you want a feeding tube, etc., or CPR, or do not resuscitate, any of those, you can put that into your power of attorney for personal care. That isn't always the same person. It often is the same person as you choose for your power of attorney for property, but it isn't always. Sometimes I'll have a client who's got a child, say for example, one daughter who's very financially savvy, who she'll want to have, he or she will want to have for their power of attorney for property. But then they'll have another child whom they see more often or talk to a little more often, who's a little bit more knowledgeable about their personal wishes as to where they want to live, or what kind of medical care they want, or even things in some, you know, depending on the person's beliefs, you know, a special diet or anything like that. So they may want to name that child as their power of attorney for personal care, or even their best friend or whatever, someone they feel who is close to them personally and knows their personal wishes. It's a bit of a different kind of category, I guess, than the power of attorney for property. Power of attorney for property, you want someone who you trust implicitly, financially, right? Power of attorney for personal care, you want someone you trust with your own personal wishes that you want to have followed if you're not able to speak. And the power of attorney for personal care, that comes into effect only if you are unable to communicate your own wishes yourself. And so it's a little bit more of the moment. But it's also very important to have, because if anything happens and you end up in the hospital and you're unconscious or whatever, unable to give directions, and there's something specific that you want, or even actually now more and more hospitals are actually looking for it before they make any decisions on your behalf, even for spouses. So something to keep in mind. It's not always automatic that the doctor will turn to the next of kin, you know, for larger, and actually that was a good example that I was using with regards to the two elderly sisters, is that, you know, even for the personal care decisions, the social worker was saying to her, you know, we understand you're her only living relative, but we need a power of attorney from you. So, or power of attorney from her, rather, appointing you to make these decisions. We can't just go on your, you know, they want to protect themselves. And this is I think, a large part of the reason why this legislation came into place, is because not only it gave your average person some predictability and outline, but it also protected the doctors and nurses as well from any liability, because this way it's in black and white. So, you know, they will make the decisions that they feel are necessary for your care, but they always want to know if there's a power of attorney, and that can impact on the kind of treatment, obviously, you're going to get. So it's something to, it's also fair, you know, pretty important for that as well, and something to keep in mind.
One question, Wendy.
Sure.
In terms of the power of attorney for your financial things, yeah, and all that, do you need to have say a trust company, or as opposed to a family member? Would that be better, or?
That's a personal choice. A lot of trust companies, while they will, we can talk about that now with regards to wills too. A lot of trust companies, first of all, you're going to be signing an agreement with a very detailed and specific and fairly costly compensation agreement, compensation plan.
That's right.
Many of them don't, and it depends on the bank or the trust company, many don't like to do power of attorney for property, because that's quite involved. It's day to day, right? It's like, I mean, paying your bills, it's doing your taxes, it's buying your meal plan if you're, you know, or selling your house or something. So they're not that keen on doing being an attorney for a power of attorney. And keep in mind too, I wish they didn't choose the words they did, because they're very misleading. Attorney in this case is the person you choose, not a lawyer. I don't know why they use that. And it's the same thing with power of attorney for property. It's also misleading because it's much more than property. But anyways, so I mean, they're not really, like I said, some will, but they're not that keen on it, and there's a fair cost to it. They certainly won't for a power of attorney for personal care, and I wouldn't recommend it for a power of attorney for personal care, because that's very personal. You want someone you know well. And even the power of attorney for property, if you've got someone that you trust, I would always, particularly for a power of attorney for property, I would always recommend a friend or a family member. And it doesn't have to be a family member. If you have a friend that you're close to, or an aunt or a cousin, whoever you're close to and whom you trust, you know, with your finances, etc., then, you know, that's who you want to choose. But trust companies and banks, like I said, they're not that keen to be power of attorney for property. You would have to check with the bank or the trust company, but there would be that compensation plan, and they are that kind of removed.
Yeah.
You know, even as an estate trustee for your will, an executor, for example. Again, there's usually some very detailed compensation clauses that they want to put in, and actually many banks will not automatically be your executor / estate trustee unless you've got a certain amount in your estate. Right? Not all of them will tell. If they think it's not, if it's below a certain amount and you want to name them, they'll say no. You can't. But then if you do, like I said, there is some, and we can talk about this for wills too. There is executors, and I'll call it a trustee. It's executor / estate trustee who deals with your estate under your will. They are entitled. It's not formally legislated, but there's a rule of thumb for compensation, which is more or less, it's 2-point-something% of receipts in, basically it works out to about 5% of the value of the estate for compensation for an executor. That's usually the standard, unless you put something in there that's a different amount, but that's usually the standard. So the trust and bank companies, they often go past that, so I mean, it's up to you. But I mean, if you've got a long-standing relationship with your bank or trust company, the thing is too, you may have a long-standing relationship with one of the people, the manager, whatever, that person may leave, So then it's the bank or the trust company and whoever they have appointed to manage it, So I mean, it's a personal choice, but you do need to keep that in mind. Those factors.
Just to follow up on that, does it have to be laid out by a lawyer, or there are some kits available, simple kits?
Oh yes, and I am going to talk about those actually. That is coming. That's a panel coming up, and we'll talk about that. I just want to go over the advantages of having of your creating your own power of attorney as opposed to leaving as opposed to having nothing, so to speak. You get to choose who will manage your affairs. If you don't have anyone, then the Office of the Public Guardian and Trustee doesn't automatically take over. They are there to take over if no one comes forward. So if there's no family member or friend who comes forward, the Office of the Public Guardian and Trustee then will step in and manage your affairs. If a family member or friend comes forward, they can apply to the Office of the Public Guardian and Trustee, or they can apply to the court and be appointed. Now that is more costly in both time and money. And the other risk too is the person who comes forward may not be the person that you would have chosen. And in some families that's the case. It may be a brother or sister or a child that you would really rather not have managing your affairs, but they may be the ones who actually, if you don't have a power of attorney, they may be the ones who step forward and apply to be that, for you. If you go through the Office of the Public Guardian and Trustee, it's not as costly if the person makes the application through the Office of the Public Guardian and Trustee. It's not as costly, but it's much more strict with the reporting requirements than if you go through the court. However, if you apply through the court, there are still reporting requirements, like you have to keep track of all the receipts, etc., that that you've, all the expenditures, disbursements you've made on behalf of the person who you're attorney for. You have to keep a record of all of that. But the Office of the Public Guardian and Trustee has fairly stringent reporting requirements. Court has reporting requirements, but not as stringent, but it's more expensive. To be court appointed, I've heard it can cost up to $5,000. So when you're looking at the cost of creating your own power of attorney compared to not having a power of attorney and having to have someone that may not be of your choosing apply and have a greater burden in reporting or spend more money, then doing your own power of attorney becomes rather cost effective. Now, powers of attorney are separate from your will. Powers, I sort of think of it or describe it as on a continuum. Powers of attorney can be in effect and used up to the day that you die. The will only comes into effect after the day that you die. So powers of attorney and the will are never happening at the same time. And the will, again, that allows you to make your own choice as to who administers your estate. That's your executor / estate trustee. It allows you to give what you want to whom you want, and it also allows you to put clear direction in your will so your wishes are followed. And there's a number of different areas where you'll be wanting to put clear direction. And I may talk about it in another one, but another panel. I do. But anyway, yeah, I do. I try to talk on the next one, actually. But that's the benefit of having your own will as well, because otherwise it falls to the Succession Law Reform Act, and that's the provincial legislation. And I'll talk a little bit more about the distribution under the Succession Law Reform Act. So again, the will gives you the advantage of choosing who you want to administer your will. And keep in mind too, an executor / trustee, it's, you know, I mean, I'll have people come in and say, you know, I want to name all 4 of my kids. You know, that can be a little complicated because then all 4 of them have to sign everything. You know, it's, you know, they all have to agree, or else you have to put a mechanism in for if they don't agree, how it's going to, you know, how the decision will be made. It gets complicated. You can do, certainly you can name 1 or more executors if you wish, or you can name 1 executor and an alternate, or 2 executors and an alternate. It's just, it gets a little more complicated. And you have to keep in mind, this is not a privilege, it's a job. It's a job that has an end to it, but it's a job, and which is why there's compensation allowed for it. Because basically the person who's administering your will, what they're going to do is they're going to contact, there's a number of duties that they have. They're going to contact, you know, CPP, OAS. They're going to have to determine where all your accounts, your bank accounts are, what's in there. They have to determine all of your assets. They have to then apply to the court for the certificate of appointment of executor, which used to be known as letters probate. They have to do your tax returns. They have to distribute everything as well. So I mean, there's a lot of work involved. Usually it takes, generally speaking, just over a year until they have the second tax return done, the estate tax return done, and the other taxes. It can take longer if there's any kind of conflict over the estate. But generally speaking, it takes about 1 to 2 years to actually administer estate, depending on when the person passed away as far as the taxes. That it's kind of Revenue Canada and where the tax returns are up to that kind of determine if it's going to be a little bit longer or, you know, within the year kind of thing. So it's you know, it's a fair amount of work, and like I said, it's, you know, it's not a particular privilege. You don't have to feel like you're leaving someone out. You want to name someone who you feel will take on the challenge, because not everybody will. And if they don't, they can renounce, and then your alternate steps in. So, you know, you want to make sure that the person that you name knows that you've named him or her, and make sure that they're okay with that, because those who have done the administration of an estate are sometimes a little more cautious about accepting that, because they know what's involved. So you want to make sure, I mean, most people don't mind doing it, but when it's for a loved one, but it is, you know, there is a fair amount involved in it, and you want to make sure that you choose someone who's willing to do it. They don't have any discretion. They have to follow what's in your will. They can't change it. They can, or they may not be a beneficiary. That doesn't matter what. They don't have to be a beneficiary. They don't have to not be a beneficiary. The person you name is the executor. Particularly in couples, generally speaking, they'll name each other as their executor, and they're usually the sole beneficiary, and then everything to their kids. You know, that's your straightforward, most wills are straightforward, but that's your, you know, your typical couple will kind of thing. And, you know, because they want obviously their spouse to be the one who's dealing with their estate, and usually, so I mean, that's, you know, that's the same. But you can also have someone you name as an executor. It can be a good friend, you know, it can be your lawyer, it can be your banker, it can be, you know, whoever you choose. That's a little different again if you choose your bank to do that, because it is a finite timeline to that job. There is a finite timeline. But like I said, you have to check with your bank, because sometimes they have criteria that you have to meet before they'll take that on. And like I said, there is usually a higher compensation scheme as well. So that's the importance of being able to choose who you want. And the importance of proper drafting, and this goes to the pitfalls of will kits and holograph wills, which Amelia, you were raising earlier. A will has a certain protocol to meet with regards to witnesses, with regards to the signing, with regards to who witnesses, etc. There's also usually, usually done at the time of the will being signed or shortly after, there's an affidavit of execution which has to be prepared, and the affidavit has to be witnessed by a commissioner, often a lawyer, anyone who's a commissioner, but usually it's the lawyer who prepares it and attaches it, and it becomes, the will becomes an exhibit. So that's not always covered in will kits. They also don't, and holograph wills are handwritten wills, which in a pinch they're valid. Handwritten wills are valid. It has to all be completely in your handwriting, but it isn't, preferably dated. But they are valid. The thing is, they're easily challenged. So that's one of the pitfalls of the holograph will. The will kits, again, as I said, they may not cover all of the protocol. They may not have, they're very generic, so they may not address specific situations. And in today's world, will drafting has gotten a little more complicated with blended families and second families. You know, so you have couples who may have remarried and have adult children, and they want to make sure that their children aren't left out, et cetera, et cetera. And there's, and to deal with that, there's a lot of Family Law Act considerations about what a spouse is entitled to upon your passing. So you have to be aware of all of that. And sometimes, you know, often the will kits don't address these. They're too generic. They just simply aren't made to address specifics such as that. So those are some of the pitfalls. And that's, again, the importance of proper drafting, which leads from that, is that if the will isn't drafted properly with the proper witnesses, the two witnesses, both over 18, can't be a beneficiary, et cetera, et cetera. And in my handout, I've given the list of who can't be a witness. So if you have any of those errors, then your will be invalid, and it's like not having a will at all. So then you know, so you've got to be careful about that. And if you don't have a will at all, that's often too when conflicts can arise after your passing. And true, many people say, well, I'll be gone, I don't care, which is a good approach. But at the same time, if it's your children who are fighting, you do usually care about that. You know, so, and I've seen it, even in close families, more than I care to. I've seen it where they've all gotten along and there's one asset, like a house or whatever, and there's no will, and all of a sudden you've got factions within the family, and you've got arguments, and you've got fighting, and then you've got money going out as well. So you've got not only, more importantly, the stress that's going to be and tension that's created among your family members, but then you've also got possibly a very costly court battle. So it really does make a difference if you have a properly drafted will in place. It does avoid conflicts. It's also, a will is where you can put funeral directions in as well. But to be honest, by the time people get to the will, the funeral's already happened. So you want to make sure, and I'm going to give you a little story here which still upsets me to this day, and it happened over 10 years ago. But I had a client who was very, very clear on her wishes as to her body being donated for science and research. Even brought me in forms from, you know, the Ontario government to read. This was 10 years ago before they had those new forms they have out now, you know, and was very specific about what she wanted. And she named her sister, she was on her own, she named her sister as executrix, and they came to see me. And of course, I don't usually see people until after the funeral's happened. When they come, that's when they come looking for the will, the original will, because often the lawyer will retain it safe storage with when it's left with the lawyer. Most people prefer that, but I'll talk about that in a minute. But and in her will, it was very clear what she wanted. She put her directions in, what she wanted done with her body, and you know, etc. What her funeral, you know, she wanted to be cremated and that kind of thing. And when they came to me, the funeral had already taken place, and I said, oh, I said, you know, it's in her will that her body be donated, cremated, etc., etc. Oh, we don't believe in that. We just had a regular funeral. Oh yeah. I was really upset. I was so upset. This woman had been so dedicated to what she wanted to do, was very important to her, you know, and it was like, but she said, no, we don't believe in that. We didn't want to do that. And there's no recourse. Yes, the executor can make the decision. The funeral directions are directions, but in that case, the executor has, and who's going to challenge it? The person's gone, right? Who's going to challenge? Maybe it can be challenged, but there's obviously no one who can ever challenge it, right? So that's the issue. So whoever you're naming as your executrix, and this is you can put your funeral directions in your will if you think. My rule of thumb is if you think there's going to be a conflict, and the person that is going to follow your directions is going to be on the hot seat with somebody else, put it in your will so that person then has that for her defense, his defense. But my more key piece of advice is talk to your executor, executrix. Make sure they understand exactly what you want and that they will follow that. Otherwise, choose someone else. So if this is something that is very important to you, that means that you make darn sure that the person that you've named is going to follow your directions. And then that's who you name. Otherwise, you know. My last key of advice on drafting a will is don't dictate from the grave. No, that sounds a little morbid, but you know, I mean, I've had a couple of, I'll just give you again a couple of examples. A situation where the several siblings owned a cottage up north, and the final sibling, the aunt, who had possession of it and had it in her will, said it was to be kept for 20 years for the family's use, which is always a lovely idea, but your family often has different ideas than what they want as a family cottage when they begin their own families. And she had passed away in BC, so that's where the will, well, you may create your will in whichever province, and it can still be good across provinces. And I've even done a will for a couple moving to New York and created an international will. That's fine, as long as it meets the criteria of the province that it's in. And just for an example too, and I'm digressing a bit, but for example, a power of attorney in Alberta only requires one witness's signature. Ontario requires 2. So that you would want to redo. But the will follows the same criteria in Alberta and Ontario, so it would be fine. You know, so if it's the same criteria, you're okay. Anyway, she passed away in BC, and the will was probated in BC. This cottage is in Northern Ontario. There's a cousin up there who wants to buy, but it's now been left to like all the nephews and nieces. There's there's about 10 of them. Okay, they all agree it's going to be sold. They've got to buy everything. Well, the executor and the alternate, of course, over the course of the 20 years, because I think it was her brothers, had passed away. And so it falls to the son of one of the executors, but he has to get that confirmed by BC. He's in Ottawa. The closest relative to BC is his sister in California, but she's not willing to go up to BC to do this because it's kind of it's difficult to do from a distance because you got to find a lawyer there. They also didn't want to put the money out because there's no money in the estate, and this is one of the reasons why they wanted to sell it. Another thing you have to consider when you try to plan too far ahead is that there's property taxes due, there's upkeep, and there's no money in the estate for this. And now you've got your next generation who are all scattered, and they've got their own lives, their own families. They don't want to be putting their money out because they're not using this cottage and they don't want it. Well, he first came to me several years ago, and I told him the process that needed to be taken, but there was nobody who was in the family who was really willing to take the process or put out the money. It's about 10 years later now, and that cottage is still sitting there. They've lost their buyers. I had another couple who had minor children, and they were naming the guardians for the children. The guardians were in Toronto, and they said, okay, but we also want to put it in our will, don't sell the house because we want the children to have it, and we want the children to live in it if they want, or to have it to sell later on. The kids are like about 9 and 10, and I said, okay, but your guardians live in Toronto, so the children will go to Toronto to live. Well, unless they want to move here. And I said, what are the chances of, what are the chances this couple's going to get up from Toronto, move here so that they can keep your children in the same house? what are the chances they're going to give up their jobs, their lives, you know, really? You know, what, is that really going to happen? Oh yeah, I didn't think of that. You know, and then it's like, okay, well then we just want to keep it, you know, they can, I said, okay, so then they have to rent it out, because they have an obligation to the minor children to do whatever they can to increase that investment or maintain that investment. So they're going to have to rent it out. So they're going to have to be landlords from Toronto on a property that they really didn't make a choice to do this with. You know, do you think they're willing to do that? Oh, well, I haven't really talked to them about it. I said, well, maybe you should. Well, maybe they won't really want to do that. So maybe not. You know, so you have to kind of, so you don't want to be dictating from the grave for 20 years down the road. So you want to deal with your assets and, you know, do what you can for sort of the first level, and then let people figure it out from there, because you never know what's going to happen or how a certain, you know, you may have a child, you think, oh, that child will never leave Ottawa, so I know they're going to want that piece of property. Well, that child may get an incredible job in Dubai, you know. So you've got to kind of take that into consideration, not get overly complicated in what you want to do or try to control too much for too long. Sometimes you just have to let it go. So as I mentioned before, if there isn't a will, you're considered to have died intestate. And then it goes to the distribution of your estate goes to the Succession Law Reform Act, the SLRA. That is very precise as to the order it goes in. If there's a spouse, everything goes to the spouse. And actually, if you're separated, but you don't have a separation agreement in place, releasing any claim against the estate by your ex-spouse, and if you haven't divorced yet, then that spouse will still get, and I've known, again, a situation where they were separated for like 13 years, there was never a separation agreement put in place with regard to property or release, usually the separation agreement. Family's my other area, family law is my other area of law. The separation agreement, you'll have clauses in there saying, hey, my ex-partner cannot make any claim against my estate, is not part of my, if that party is in my, spouse is in my will, it's no longer, those parts of my will are no longer valid. So if you don't have that in place, and if you haven't divorced, even if you've been separated like 13 years, it'll go, if you don't have children, it'll go completely to the spouse. If you have children, in Ontario, the first $200,000 of your estate will go to your spouse, if you don't have a will. Then the rest of it, the rest of your estate after that $200,000 will get, if you have one child, will be divided 50-50 between the spouse and the child. If you have 2 or more children, then if you have 3, one-third will go to the spouse, and the other 2/3 will be divided among the 2 or more children. So if you have 3 children, you have 2/3 divided among 3, etc. So it may not be the distribution you want. And if you have no spouse and children, then it goes to the parents. If there's no parents, then it goes to your siblings. If you have no spouse or children or parents, it goes to your siblings. If your siblings have passed away, it goes to their children. So, you know, it may not be the order you want it to go in. If you have no spouse or children, you may want your estate to go to a good friend as opposed to siblings, you know, that you may not know, you may not see or may not have that close relationship with. Or you may want to share, or you may want it to go to charities as well. And that's another thing that you can do in there as well, is if you want to include charities, you can put that in your will as well. And often then you can, if you want to, you can, depending who you're donating it to, you can do it in memory of someone or yourself, and you know, depending what you're donating. I've had this situation where they've had like a wing named after the person, so you know, their son had passed away early from a heart attack, and so they named, they had an institution, a college or something that was very important to their family. They had a wing or something named after their son, so his memory kept going. Or, like I said, even if you just, you know, any nonprofits you want to give donations to that are important to you, or that you can, like Cancer Society, Old Forge. they didn't even say that to me to do that, but that's the, you know, anything you can.
Do you get a receipt for your income tax?
Yes, you do.
Okay.
Yes, you do.
That's good.
You do. And that was the other piece as well. Yes, you can get a tax, yes, your estate will get a tax receipt, exactly. So that will, yes, that's considered a charitable donation. Exactly. Sorry,
Wendy, if you don't have, if you are a widow, your parents are no more there, you have no siblings, and if you don't have a will, what happens?
Well, that's just it. If you don't have, oh well, then they start looking at cousins.
Cousins.
Yeah,
okay.
they'll sort of go down the progeny line,
right,
so to speak. So yeah, so it'll just keep looking within the bloodline, and then if the bloodline runs out, if there's no cousins or anything, then it kind of goes to the.
Does it go to the government?
Yeah, and kind of sits there. Yeah, that's exactly where the last stop is. So yeah, sorry.
Thank you,
Carol.
With banking, today's banking and PIN numbers and everything, and
Yeah.
if you don't share your PIN number, right?
No,
So
I don't.
what happens? What happens if you have a lot of money
Yeah.
wherever and it's under a PIN number?
Oh, but it isn't, because your PIN numbers are always connected to your account. It's always connected to an account.
Oh, okay.
Right?
Oh,
yeah.
Oh,
Like it's your bank. I know I never go into the bank anymore either.
No.
I always use the debit machines or you know,
Right.
I pay by debit. I rarely ever see my banker or teller. I mean, I never go in. But the fact is, I do have a bank account.
Thank you.
Right.
It's been on my mind for a
Yes,
while.
no, because what happens is with your executor, once the certificate of appointment is issued by the court, that's what's called probate. Is you make an application to the court for the certificate of appointment, and once that's provided, you get a certificate of appointment of a state trustee, and then once you have that, it used to be called letters probate. Then you take that to the bank and to any other asset holder, and then they'll transfer it over to an estate account that you've created.
Thank you.
So you just go right into the bank, and then they'll have you just even in fact give the name. Hopefully, and this is something I also recommend too. When you do your, when you have, like when I do a will, I usually keep the originals up to the person. But one of the reasons why the lawyer keeps the original is that it's safe storage. Because a lot of people don't realize, and I've had people bring me in originals where they've written on it, and that can invalidate it, or parts of it, or they've lost it. Well, you can't use a copy to probate. It has to be an original. So you want to make sure that the original is in a safe place. And so once you, like I said, once you probate that, and you're named as executor, usually I tell my clients, with your copy of the will that I give you, do up a list of where your assets are, like what your account numbers are, where they're located, which bank, you know, et cetera, et cetera. You know, you don't even have to put the value. You just need to put the details of the account and the location, and keep that with a copy of your will. You don't have to give it to anybody. They don't have to see it until your death, until they need to. You know, and then that person can go to the, otherwise they've got to, otherwise the executor has to search through, that's the other way they find it. They search through all your records, your house, until they find it. It's much easier if you just have it listed and they can just go in. If you go in and say, look at, I know this person has an account here at the Royal Bank. You give the name, you give the certificate of appointment, they just go into the computer and pull up everything that's connected to that account. There you go, and that's it. So yeah, I know. It's technology, eh? You never know.
What does SLRA mean?
That's the Succession Law Reform Act.
Okay.
That's the provincial piece of legislation. And it is provincial. Each province has their own pieces of legislation, so it depends. And that's what I was talking about earlier about the criteria. You want to make sure if you go to another province that your will is still valid, depending, you know, that it meets the criteria. For wills, it's pretty, I've practiced in Alberta, and I've looked at BC, I know Ontario, and it's pretty consistent across the board, so you should be fine. Again, too, if there isn't a will is if you're a couple with dependent children, or if you have a dependent adult child as well, particularly one who is on benefits. You know, there's what's called a Henson Trust Clause that you can put in so that the child can receive funds from your estate, but in a manner that it still allows that child to be eligible for benefits, and just as important, health benefits, right? The drug card, etc. So that, you know, if you have a minor dependent child and you want to make sure, because you know that what's in your estate will help that child a bit, but isn't going to be long term, and you don't want that child to lose their benefits, then you can manage that in a will. Same thing with minor children. If you want to name a guardian, you can name it what's called a testamentary guardian, which will give the court guidance if there's a challenge or when the application for custody or care or guardianship of the child arises after your death. Then if you've got direction in your will, then that can assist the court if there's a conflict over whom the child will go or the children will go live, or the guardian or their property, who's going to manage their property if they're obviously minors. And you can also too put in your will at what age your minor children will receive the estate. Otherwise it's 18. And I know a situation where an 18-year-old's in, and I know actually I've spoken to a colleague of mine, a friend at Edward Jones, who's seen it as well, because I had a situation where it came up, where, you know, the minors were going to, minor children were going to inherit or receive funds, you know, about $200,000 or more at 18. And he said he had about 10 situations like that. Out of those 10, maybe 3 of them didn't blow it within the first 3 years. You know, they're 18, right? So this way you can actually name, like if you think 21, you know, and you can do it, you can also put a discretionary clause in there saying the child will get the money at 21, but the person I'm naming as their financial guardian has access to those funds for that child's care and education, care, health, and education, so that if the child wants to go to college or whatever, the funds can be accessed to pay for that. You give that to the person you name to take care of it. Otherwise, you have to make an application through the court, and it's a whole, I've done that too, through the Children's Law Reform. Anyways, it gets more complicated. As well, if you don't have a will, then for your administrator, your executor / trustee, whatever term you want to use for the person who will administer your estate, they'll have to apply to court and bring an application to the court. And again, that's more costly and time consuming. So those are the kinds of things that you want to avoid. You can also, in your will, minimize your probate fees. Ontario has one of the highest probate fees in the province. And I had been doing estates here, obviously in Ontario, before I went out to Alberta. Alberta has one of the lowest. In Ontario, it's $5 per 1,000 to 50,000, then $15 per 1,000 over and above that. So if you have a house that's going to be included in your estate and it's $300,000, and you're looking at $250 for the first $50,000, but then $15 per 1,000 after that, that's a fair chunk of money that you're going to be paying for a probate fee to the court, which is the province of Ontario. Alberta, their fee, and it doesn't matter how large your estate is, caps at $450. So you can have a $2 million estate and pay $450 probate fees.
In Quebec, you don't pay any.
In Quebec, I think I think you do. I have a chart
They
actually.
do that now?
I think there is some, but I think there's a few other provinces that cap it as well. I can't remember. I did actually have a chart, and I didn't unfortunately bring it this morning. But there are a few others that have caps too. I think there are. Maybe there aren't. I don't know. There might be now.
Quebec has any.
If they
do
do
have another name.
Yeah,
Or
well, that's
other kind
could
of,
come under another name, but it's probably minimal.
Yeah.
But Ontario's is not. So
It's not.
you can have your estate could end up paying several $1,000s in probate fees, depending on your estate. As I said, it's based on the value of the estate. Some of the ways you can minimize probate fees, however, if you have joint assets, they're exempt from the value of the estate for probate purposes. If you have a house that you own in joint tenancy with someone, like with your husband or your partner or your spouse, that's excluded. That has what's called a right of survivorship. So that's excluded from the value of the estate for probate purposes. What happens is you just bring an application, a survivorship application, to the land registry office. You don't have to wait for the certificate of appointment from the probate or anything like that. And probate just is the term for the court application to have you confirmed as the executor named in the will, to confirm that it's a valid will and you are the valid executor. And like I said, they issue what's called a certificate of appointment of estate trustee. It's a one-page thing. That's probate. But it takes a little while to do it because you have to make the application to the court, they have to process it. It can take, and before that you have to determine all the assets and the value, etc. But if you have a joint asset with the right of survivorship, you just go and bring the death certificate. They may have forms if it's a bank. If it's a house, it's the land registry. If your house is, if you're listed on your deed for your house as tenants in common as opposed to joint tenants, most couples that buy houses are joint tenants. But if you're listed, if you're a parent and child, sometimes it's tenants in common. And then in that case, that becomes part of your estate and it goes through your will. So the other person doesn't have the right of ownership if you pass away, or the right of survivorship. That other person only has your share of that asset, that house, if it's left to that person in the will. So it comes under the will. There's also, so anything with joint assets, anything with a name, any asset with a named beneficiary. So if you have RSPs that have a person named as a beneficiary, not the estate, but a person named, that's not included in the value of the estate for probate fees. And as well, again, you don't have to wait for probate to have those assets transferred to the beneficiary. Generally speaking, again, they want the death certificate and to fill in their forms.
My understanding was that for RSPs, it's mainly the spouse.
It can be whoever you need.
As a beneficiary without taxation.
That's your free choice. Oh, without taxation, that's a different, I'm talking about probate fees.
Okay.
Revenue Canada is a different, capital gains and all of that, that's a different thing.
That's different, yeah.
Although actually, if it's your principal residence, I believe it's up to 6 months after, if I'm not mistaken, maybe it's a year, where you can transfer it, like say you share a house with your ownership of a house with your child. Say you've added your child onto the deed to avoid probate fees, etc. And it's your principal residence at the time of your death, then you can transfer it to that child without capital gains. Yes, within a certain period of time. Yeah.
Joint asset gifts, what do you...
/ or a gift declaration. For example, say you have an incredibly expensive painting. And prior to your death, you'd said, I'm going to keep this in my house until I'm gone, but this is a gift to you. So that wouldn't be included in your estate value because you've already given it away as a gift. Or like I said, if you own any real estate outside of the province of Ontario. So if you own a cottage in Quebec, now you still have to do the probate to give them a certificate of appointment because Quebec will ask for it, I know that. But it's not included in the value of the estate to be taxed on for the probate fees. And when I'm saying taxes, I'm just talking probate fees. I'm not talking Revenue Canada. That's, like I said, separate. But even there's a few, little concessions as well, so you can avoid capital gains, etc. But as far as your RSPs and things like that, you've set them up to roll over, kind of thing. That's all Revenue Canada. So, but the value of that RSP, regardless of who's named as beneficiary, that value does not get included in the estate value for probate fees. So that would be the end of my presentation. It's a lot of information, and I've given you a handout which actually goes over a lot of those points that we've raised. But if there are any other questions?
Well, investments, it's just capital gains, or if you have a lot of GICs or
and you can't name beneficiaries for GICs, right?
You can't?
No, RSPs you can, but GICs you can't name beneficiaries.
RSP?
I don't believe so. Has anyone ever named a beneficiary for GIC? You can own them jointly with someone, but you can't name a beneficiary.
No.
And some mutual funds you can't name beneficiaries. It depends on the asset.
RSP you can name beneficiary.
Yeah.
And just GICs and that, no.
GICs, not that I know. As far as I know, you can't name beneficiaries. Now, mutual funds, some you can, some you can't. You'd have to talk to the person who you're dealing with when you're...
Mutual fund, talk to someone.
Anything that you can name, they'll tell you when you're buying whatever you're getting, right? When you're buying your asset. They'll tell you they'll ask you who you want to, if there's a beneficiary with that asset, they'll ask you who you want to name as your beneficiary. If they don't, then there's no beneficiary, and that gets included in value of your estate.
Nanny Kluche, please pick up extension 1150. Nanny, extension
So
1150.
you'd have to trust your investor that even if he puts their
Well,
name on, that it's available.
Well, the thing is, you'd have to, if, as far as the investment, like, I mean, whatever your, like, for example, life insurance, you can name a beneficiary.
Yes.
Right? And you can name more than one. So if you have 3 kids and you want to name all 3, you can. The public service, the group, the death benefit, you can't, or at least you couldn't name, and I believe it's still the case, you could only name 1 person. They didn't allow you to name more, and I don't think they've changed it yet. But a lot of life insurances or RSPs, you can name more than 1 beneficiary. But the thing is, I mean, that would, to me, should be, I mean, I'm not an investment counselor, so, but that to me is part of it. If you're going through investments with someone and the person's deciding to buy this one, they're going to be filling out the form, and if it has a beneficiary, then I would expect that would be part of the form. Who do you want to name as beneficiary?
Yeah,
Right.
it usually is not.
Part of the form?
Yeah, I don't think so.
Maybe, well, maybe
You know,
they
even
don't
if they did
mention
have
it.
it, you want to be sure that the
Some of
government-
them
But
ask
usually
you.
when you're purchasing it, like I'm thinking of RSPs, usually when you're purchasing it, when you're filling out the form, that they you know, you have to fill out the form initially, right?
Yes.
Yeah, I'm thinking, yeah, you usually do. Usually the person will ask
Usually
you,
there
do
is
you want
some
an
RSPs, there is a,
RSPs.
you can designate somebody?
Yeah, RSPs, you can designate a beneficiary. Yeah,
Oh,
for RSPs.
But not for a GIC.
Not that I'm aware of.
Mutual funds, I think.
Some you'd have to talk to,
Registered.
it depends on the mutual fund, so you'd have to talk to your investment advisor.
Okay.
Like, I guess the point is, ask the question. Say, can I name a beneficiary for this asset? And then name a beneficiary. Don't just, because maybe some of them wouldn't ask you. Maybe they're just going to automatically put down a estate. Well, if they put down a estate, then it still gets distributed the way you want, because if you,
Yes, because
hopefully, because if you're leaving it all to your kids in equal shares, that, you know, when you want, but sometimes you know, I mean, then that'll go in, but then it increases the value of the estate. That's where you get the fees increased as well. Plus, sometimes you may want to leave this amount to someone, and this amount, you know, you may want to leave all of your estate to your kids, but you may have a niece or a nephew or a friend that you want to give a specific amount, and this RSP is that amount, so you may want to name that person, you know, as the beneficiary, and then that's how they get, you know, a gift from you. You know, so I mean, it can also not only avoid probate fees or minimize probate fees, but it can also be a tool by which you can control who you want to give what to. And it may, you know, it may provide that purpose. Because sometimes, you know, people aren't sure how much is going to be left in their estate. They're going to say, well, I want this person, I want, or, you know, or this, okay, I want to divide it all among my children, but, you know, this child I helped out a lot, and this child I really didn't, so I'd like this child to get an additional $5,000 from the estate. But I'm not really sure if my estate at the time of my death will have enough in it to cover all my expenses and give this child an extra $5,000. So I've got this RSP, so I'm just going to name my child as the beneficiary. There's the $5,000. You know, so that's a way that you can, you know, you can address it. That's a tool you can use to sort of, you know, if you have a little bit of diversity in what you want to give, then that may be a way that you can address it. You know, so it's always worth asking the question if there's a beneficiary for that purpose. You know.
what would be your advice in terms of skipping a generation for giving your assets to?
It's a personal choice. You can do it. You have no obligation. The only obligations are if you're married. Excuse me, there is the Family Law Act with certain provisions that you have to be cognizant of. Because, for example, under the Family Law Act, if you don't leave your spouse anything,
Yeah, you have to leave certain amount.
then they can elect to take an equalization payment under the Family Law Act. And I won't go into all the details because then we're getting into family law, and I can just blurb it out because I work in it all the time, and you're going to be going, what? What's an equalization payment? I can tell you how it's all calculated and everything. It's just going to give you a headache. But there are certain provisions under the Family Law Act which says if you're not left, you know, then you can elect to take an equalization payment, and it holds up the estate. There's also dependence relief, for minor children. If you haven't left anything, if you're paying child support for a child, and you haven't taken care of that child, or in your estate, there's dependence relief. There's other factors that are involved that you need to be aware of. But if you have adult children who are not dependent, there's no obligation to leave anyone anything, and there's no and I've had people in, but families are all unique, right? And they all have their own dynamics. And I've had families in where they'll say, this child has alienated him or herself from the family. I just want to leave something to these 2 children here. That's fine. Or this child has an issue with certain substances that if I give anything to, it's just going, I know where it's going to go. So I just want to, if it's an adult child, there's no obligation. So if you want to skip, if you feel and others will say, this child's really well off. This child's not. I want to help them. That's, I want to help this child more, or I've helped this child and I want to give this child more. Or these, my kids are all well established, they don't need it, they've got more than enough money to do them. But my grandchild's coming up, my grandchild's 21, I want to help him or her get started, so I'd rather leave my money to my grandchild. You can do that. That's not a problem. It's totally a personal choice, and there's no obligation to do otherwise. It's up to you. Yes?
What happens in an instance when you have a will that you've created, a legal will with a lawyer, and then you have something that's found after the fact in your home that you've written and someone has witnessed, like a second will? Which will becomes valid?
It doesn't matter who you do the will with. If you do it with a lawyer, then you're less likely to have it challenged, hopefully. The lawyer knows what they're doing. But if there's another will that's found later, it's done, if it's a handwritten will, for example, or if the person's gone to someone else, or just done their own will up, they followed all the protocol. It's whatever is the last dated will that's done properly that takes effect. Usually if a person, and I've actually had people who've come to me and say, I don't even know where my lawyer is. I did that will 15 years ago. I can't get the original back. Well, what they do is in the new will, they revoke all previous wills. And then, and even if it's a handwritten will, if it's done after the date, might be a little more open to challenge. If you're going to redo your will, make sure it's done properly. But if you come across a will that's a closer date than the previous one, I think that's more recent than the one that you knew of initially, and it's done properly, there may still be people who challenge it. You can always challenge it. Whether or not it's a successful challenge is another issue, right? You can always challenge anything. It's just whether or not you actually have any grounds or will be successful. But if it's done properly, then that will be valid, and that will is what will be. But also keep in mind too, I don't know if this is a factor, but if you remarry, or if you marry, your will becomes invalid. You need to do a new will. So that's something too that, it's not just divorce that will invalidate. Divorce is more, can invalidate certain sections. It may not necessarily invalidate the whole will. But if you marry, your previous will is revoked, unless you put a clause in that will. Because I've had couples come to me who are engaged and about to get married. And if you put a clause in there that says this will is being made in contemplation of my marriage to so-and-so, and you name so-and-so, then that will stay valid upon marriage. Otherwise, it's revoked. So there's certain things too that, and I always do a cover sheet with mine which says if these things happen, speak to me about doing a new will. And you should review your will every 3 to 5 years anyways, because things change, right? Kids grow up, people move away, you lose touch with others, so it's always a good idea to at least review your will and make sure. If there's, although, I've done wills that were like 25 years old. If there are no changes and it's still okay, just because time passes doesn't mean that you need to redo your will. If it's still saying everything you wanted to say. Yeah, still fine. Okay. I think that's it for the question.
I just have one other question. What recourse does a family have if it comes to light after the fact that the person made a handwritten, very short note handwritten change to their will with a lawyer, but the lawyer has advised that the person have medical confirmation that he or she in fact knows that they are changing it because they're there with this other person.
So you're talking about a codicil? Like somebody's done a change after?
Yes.
But even a codicil, you have to have
There's a question
kind
of
of
competency.
There's
Yes,
definitely a
competency.
different, yeah.
First, I'd be surprised
That doesn't take place. So
well, remember earlier I was saying when I went to get the instructions, if I have any question about the person's competency, because it's at the time of creating the document, then before I create that document, I ask for confirmation from the doctor that they are competent to understand what, because like I said, the competence, they don't have to be competent that they understand anything, you know, that they're like, if you have somebody who's in the early stages of Alzheimer's, for example, and you know, they're forgetting things here and there, but for the most part they're lucid, right? Because that can happen. You know, even later as it progresses, you still have windows of lucidity. And you know, if you, at the time, you're taking the instructions, that person understands, this is what I own, this is who I want to take care of it, this is where I want it to go in the case of the will, then that's what you need to be sure of. So if I have a client who I think may not be coherent or enough, or there's a question mark, I will ask that person to get confirmation from their doctor that they can understand.
right, I guess my question is that was asked for by the lawyer,
Right.
not completed or not carried out.
So it could be open to challenge.
It is open to
Yeah,
challenge,
exactly.
even years after.
Yeah. So then the issue becomes, was the person competent or not, and they'll look at all the evidence around it. And I don't, you know, obviously I don't know the facts of the situation, so. But that's what I'm saying. It could, I'm kind of surprised it was a lawyer who's doing a handwritten.
No, the lawyer didn't do the person who has the will came with a friend who was to benefit from the change in the will with this change to the will, and the lawyer, I mean, the notes are there from the lawyers stating that this change should not be occurring unless there's competency from the medical,
Well, that's not going to.
and it didn't happen.
Going to be good for the person who's challenging it. Those notes will help the person who's challenging it. Because that's another thing too, and you raised two things. There's both competency and duress that you have to be aware of and careful of. If I have someone coming in with me, or coming in to see me, and you know, it's okay, my mother wants to do her will, but she's, you know, she wants me to stay in because she's more comfortable. First of all, I'll say, do you have any other siblings? Because that's a definite no. Most of the time, all of the time, what I will say is, if you want to come in and stay while I receive the information I need, like, you know, your name, your address, you know, and that's usually too, I mean, those are the questions too that I will, even with the doctor's confirmation, I will make sure if I have a question mark about it, I'll ask them questions and, you know, to see if they understand what I'm saying. Like I'll say, you know, oh, you know, well, first the basic questions like, are you married? Do you have children? What are their names? What are their ages? What are their birth dates? You know, sometimes, especially some guys just don't remember. But, you know, they'll get close. Oh, darn, my wife will know. You know, and kind of, but they'll know the children's names and their middle names, or, you know, or even if they, I'll say, you know, so where do you live, or where do you, or what did you used to do? What did you work at? I'll ask some questions sort of about their life that would be within the context of the will, but sort of lets me know, you know, if they say, well, I retired 5 years ago, then I know that they're competent enough to understand what I'm going to ask. But if, you know, if the child is in their room with me, I'll let them stay for that process. But then I'll say for the instructions, you need to leave the room. I don't care if you go down to the lobby, but you cannot be in the room. I have to make sure that when I take the instruction, and again, when I review the will for signature, again, I'll have the, you know, wait outside because I want to have a one-on-one. You know, and I've had that. I've had that with a couple where the husband left the room and she goes, that's not what I really want to do. I said, then I need to take your instructions separately. I need to speak to you separately and take them separately. I'll meet with you separately to review and sign. Because you have to make sure that they're not being influenced by anybody, you know, particularly if there's any question, particularly if it's a change to a will that benefits that person. Like if I've got a child in, you know, an adult child with their mother or father, and then, you know, the child goes, the child goes, it's not a child, but the adult child goes out to the lobby or whatever, and then you know, the father says to me, well, I'm leaving everything equally to in equal shares to my children. Well, then obviously there's no undue influence. If everybody's getting an equal share, then that child's not unduly influencing that parent, right? You know, so then I don't have, you know, then your concerns are allayed somewhat. But I always take, you know, both for competency and for influence. Those are the things you need to be cognizant of as a lawyer, and make sure that your notes are complete, as this lawyer's was, and that lawyer did, you know, did their job. You know, so there you go. But it's, otherwise, you can leave it. And like I said, anybody can bring a challenge. Whether or not they have grounds or a good case is another matter. And if they want to spend the money and they don't have very good grounds or a case, it's their money.
In my understanding, in this situation, it was brought to court, and the beneficiary did fight it, and was able to prevent the lawyer's notes from being put forward. I'm not sure how that occurred.
Oh, but it sounds like the lawyer's notes, and again, I don't know all the details, but it sounds like the lawyer's notes would have helped the beneficiary. Or is that the beneficiary who came in with a handwritten note?
Yes.
Oh, wow, interesting. Well, I'm sure there's a lot more to it than a lot more detail to it. But I think it illustrates very well the point that you need to be very careful. You need to make sure that you're solid. Mm-hmm. You know, you need to be, the lawyer particularly needs to be aware and needs to explain to the client, you know, the possible grounds for challenges such as influence or incompetency, etc. And I think it's obviously the lawyer's duty to ensure as much as that person can. Like I said, I'll ask for a doctor's confirmation. Now, I'm not going to go and check that doctor's credentials and how long he or she's known the patient or whatever. You know, if I get that's the person's family doctor, and I get confirmation, you know, that this person is competent and can understand, then I've done due diligence. But you need to do due diligence. you need to be aware of it, and you need to make sure you need to keep solid notes too. Although may not always, you know, benefit you, or may not always work out the way that you think it should. But that's court too. And that's a very good point. Court may not always work out the way that you think it should or would if something was challenged. So you've got to kind of keep that in mind too. But that's an interesting, illustrates it quite well.
It's interesting to also find out how come the court sort of would not.
Well, I'm sure there's much more involved.
There must be,
there's much more. I'm positive there's much more involved, and there's probably other evidence as well. And you know, that was possibly one piece of evidence, and maybe there was others that, you know, hard to say because we don't know the details or anything. But that's, I think, a really good thing to keep in mind is that, you know, you want to make, and that goes back actually to the will kits or to the handwritten wills. Like, it's much better to have it done properly and pay the few $100s at the time, because I'll bet you that court case costs thousands of dollars on both sides, both to the estate and to the beneficiary. The beneficiary would have gotten it back if the beneficiary won, obviously, but still comes out of the amount he would have been entitled to. So, you know, you want to avoid those situations. So you want to make sure that it's done and it's done properly. Again, a handwritten note as a lawyer, I would not. And the thing is, too, when people, I don't even do codicils, to be honest. If somebody comes and wants a change to their will, because of technology, I've already got their will on the computer. I just, rather than typing up, it's not even typing up, you're on a computer now. Before you used to have to type up, so you just type up the codicil instead of redoing the whole will, right? Well, now with the computer, it takes me just as long to just put your change in, you still have to get the same signatures and the same protocol, you know, the same witnesses and everything. So if you're signing a 4-page will as opposed to a 1-page codicil, what does it matter? It's a new will. Everything's secure. You know, instead of adding in a codicil that might be, you know, questionable. With today's technology, like I said, I don't even bother with codicils. I just, if somebody wants to change to their will, I charge them the same price as I would for a codicil. It takes me the same amount of time. It's the same amount of time for them. Just do a new will and revoke the previous one.
So there's no
Clear.
cost-effective way for doing a codicil.
No, not for me, not for my
for
clients.
Yeah.
I charge the same thing that I would charge for redoing. If I've already got your will on my computer, if I've already done your will and it's on my computer,
Yeah.
and you just want to change, then I charge you the same as I would for a codicil. But you've got a brand new secure will, saying exactly what you want, instead of a piece here and a piece there, and
Yeah.
you know, it's cleaner to me.
Are you still on Richmond Road? Or?
I'm not. I went out to Calgary for a couple of years, and I came back in 2011.
Right.
And I actually now live in Canada off of March Road. Do you know where the Brook Street Hotel is?
Oh, yes.
Yeah, I'm right beside there. The
Okay.
Canada Research Center. Yeah, so I'm up there. It's a little bit easier than the traffic. You tend to avoid the
So
traffic.
if I had a will done where you were, it's still there.
Well, no, it would have been, if I'd done your will, did I do your will before?
You know what? I don't know, but
I
thought you did.
Only because you do it familiar. If I had done your will when I left in 2008, I actually transferred all my wills to a firm called Mann & Partners on Scott and Holland.
Okay.
So your original, and I sent a letter out to all my clients at that time, but that would have been 4 years ago. But I sent a letter out to them advising them that the will had been transferred over to that firm and with all their contact information. So that's where it would be. And the Law Society always keeps track, by the way, whenever you move or transfer or retire or whatever, the Law Society is always aware of where lawyers are. I actually had, I had a will to probate that was, like I mentioned earlier, 20 years old. And the original law firm, there are 3 partners. It had disbanded, it had dissolved, and one of the partners had passed away. One of the partners was down in the Maritimes, and the other one, just by pure luck on my part, was still in Ottawa. And God bless him, he actually came to my office. He was 85 or so, on a cane, with his cane, and I said, I'll go to you. And he says, no, I like to get out and around. So he came down to my office, and you know, because they hadn't done, nowadays, like I mentioned earlier, we do affidavits of execution. That's just a sworn statement by one of the witnesses saying I was present and I saw this person signing it. And it's usually I'm the witness who signs it, and then I get it commissioned by another lawyer. And it gets attached to the will, because you need that to probate it. Well, this one, they didn't always do that back in the 70s, as a matter of course. So this one didn't have an affidavit of execution, and I needed that by somebody who was a witness, and this particular lawyer had been his client. He was one of the witnesses, so he was able to come down and do the affidavit of execution. Otherwise, I would have had to bring a motion in court, and well, anyways, but God love him, he was 85 or so and still alive. But I found him because I couldn't, like I said, his firm dissolved. I Googled, couldn't find him. But as soon as I contacted the Law Society, they know where every lawyer is, and whether they're still practicing or not, or if they're still alive or not. So you can always go to the Law Society.